Hello, this is Matt on the Moon Lambeau channel. A brand spanking new Forbes article has been written by Rosalind Layton, and if I'm counting correctly, this is the fifth article that Rosalind has written about the SEC versus Ripple case ever since all of this nonsense started back in December. And she does an incredible job of absolutely shredding the SEC. And it's just heavy critique of the completely ridiculous stance that the SEC has taken, all their behaviors. And so I want to run through this thing. And the impetus for this latest article is from from the Federalist Society. They actually put together a panel for people to discuss exactly this, the case of SEC versus Ripple. And Rosalind was actually on the panel along with John Deaton. I'm sure the vast majority of you at this point are familiar with John Deaton. He's an XRP community member who is very well known because he's actually seeking to intervene in the SEC versus Ripple case on behalf of over 17,000 XRP holders. And there was at least one person here who is not so confident that Ripple's in the right. Her name is Carol Goforth, university professor and Clayton N. Little professor of law, University of Arkansas School of Law. And so, I'm a fan of diversity of thought, so I don't care if somebody has different opinions than me. I just appreciate it when people are being intellectually honest. To me, that's much more important here, which is why in the world of crypto, when people are bitching up a storm about Ripple and or XRP, it's usually ideologically driven, and then it's not really as fun to deal with those particular humans or trolls, whatever the species may be. Rosalind shared this tweet with a link to our article and wrote, "The demand for a Ripple test is evolving whether the SEC wins its case or not." And so she's talking about this idea of rather than necessarily looking at the Howie Test to determine the security status of a cryptocurrency, maybe time for a Ripple test because we need clarity for the space regardless of what happens. With the Ripple case. Now, I do want to be clear also, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and so you should not buy or sell anything because of anything I say, all right? I'm just an enthusiast who likes making YouTube videos about Ripple and XRP and all those asshats working over at the SEC. Not that all of them are bad, but in particular, just, my gosh, what we've seen from these attorneys participating in the case, it just leaves a slimy taste in your mouth. You just licked the skin of a Bitcoin maxi troll. Like, I imagine that's what it would be like. That's not from firsthand experience. I would never do that. That's very gross. But I kind of imagine that's exactly what it would be like. And so jumping into this piece here, I'm going to start at this point here because there's this little subheading because we got to factor in does centralization and decentralization matter? Well, I mean, yes, it's certainly worth discussing here. And are there use cases outside of what Ripple offers in terms of it as a bridge currency? Yes. And so you have the subheading here: people use XRP as a currency. With the SEC's action, the value of XRP has plummeted. Some 50 exchanges delisted or suspended trading XRP, and the currency lost 75% of its value. XRP holders who were driven to panic selling after the SEC's action are outraged. John Deaton of the Deaton Law Firm and the website Crypto Law is leading a challenge to the case separately from Ripple. He filed a writ of mandamus in to challenge what he called the egregious, inappropriate action of the SEC and subsequently a motion to intervene in the SEC's case in the Southern District of New York on behalf of more than 18,000 XRP holders. Now, many of these individuals, app developers, organizations, businesses, and others swear that they had never heard of Ripple prior to the case and never saw XRP as an investment contract in any way. Yeah, exactly. So how many of you thought that you were picking up ownership in Ripple, the company, when you purchased XRP? I'm guessing all of 0 of you, right? I mean, you can find an outlier human, but would that even be like 1 out of 100,000 humans? Like, people did not think they were buying Ripple, the company. Clearly, it's not an investment contract. People knew they were purchasing a decentralized cryptocurrency that had an open market price. That's for damn sure here. But still, the scariest situation that, in my opinion, that has ever occurred happened about 6 months ago when this all began, at least for people in the United States, because understand, and this is something I was thinking through, and I was talking about it even in the early days too, it's like, we don't know exactly what's going to happen. And I find like not knowing something, facts about something that's important in life, like that can result in serious fear. And it really did. Like, so the general price volatility with crypto, I kind of tease a little bit about the people that are just emotionally driven, use emotions to make their buying and selling decisions. But I got to tell you, if you're in the United States, you could have ended up in a position where you literally could not sell your XRP, and you didn't know. Like, we have a better understanding of what's happening with the case right now, and it does look good for Ripple, at least with the pre-trial motions and so on and so forth. But and even then, we still don't know. But in the United States specifically, we didn't know if there would be any exchanges that would allow the trading of XRP. And so, not selling, if you're in the United States, not selling in those days, and not knowing if you'd lose all access to the opportunity to sell, and if it would ever come back, like, that's a serious risk for anyone in the United States. And so, like, to me, that's the scariest moment that's happened in the entire history of XRP, seriously, since inception. And we're through that. So I figure if we've come out on the other side of that and XRP's already rallied, like, I don't think anything's just going to take this down. I really don't. That's just my humble opinion here. But prior to the SEC's action, XRP was openly traded on more than 200 currency exchanges. Now, many countries are developing digital currencies, some of which may utilize the XRP ledger. The World Economic Forum noted XRP is the most relevant cryptocurrency for central banks. Financial regulatory authorities in Japan, Singapore, the UK, Switzerland, and the UAE have already declared that XRP is a currency, not a security. XRParcade.com notes some 360 different kinds of organizations which use the currency as a means of exchange, including wallets, marketplaces, money transfers, banks, and more than 150 consumer apps. Some firms pay international employees through XRP, and consumers use it to buy groceries and to subscribe digitally to Time magazine. Now, Deaton detailed a series of actions, events, and conflicts to diminish the SEC's case. In 2015, the Ripple and Department of Justice reached a settlement that XRP is a convertible digital currency, and that's a classification, convertible digital currency, and that Ripple is a transmitter of XRP registered with the Department of Treasury's Financial Crimes Enforcement Network, or FinCEN for short. Now, Ripple agreed to comply with U.S. currency laws, not securities laws. In 2017, when the SEC brought cases against initial coin offerings, it did not include Ripple. And so let's pause right there. Think about that. How many firms did the SEC go after? I think the number, because I know they claim to have brought 75 cases against crypto-related companies, but half of those had nothing to do with tokens. It had to do with companies that were somehow related to blockchain or cryptocurrencies, but they actually weren't issuing cryptocurrencies at all. The other half, I think, if not all of them, the vast majority of them, so a few dozen of them, mind you, those would have been ICOs. So those were brand new ones. Why the hell would Ripple be allowed to continue if it actually had an ICO? It's been selling all these unregistered securities, and it didn't. Of course, Ripple didn't have an ICO. But why does it get away, at least for the time being? Why do you allow that to persist? Because it's one of the biggest, most broadly distributed cryptocurrencies on the planet, even by 2017, and you're going to allow that to continue while going after these smaller firms that just popped up out of nowhere? That doesn't make any logical sense right now. And so that, to me, that speaks to the fact that the SEC wasn't even sure that XRP was a security back then, but somehow Ripple was supposed to know, right? It's completely ridiculous here. And so anyway, in 2019, the SEC accepted Ripple's $30 million equity investment in MoneyGram to extend money transfer via blockchain. And so pause and think about that. Literally, the SEC knew that XRP would be used with this partnership between them and MoneyGram, between Ripple and MoneyGram, XRP functionally getting used. If they thought that that SEC thought that XRP was a security, would they have allowed that to move forward? So I think even in 2019 they didn't know that they were going to state that XRP was a security, and they were still engaging in their investigation. But holy hell, why do you allow something like that to go through if you're investigating? It defies all logic. And so it continues here. Now, similarly, Ripple informed the SEC to list XRP on Coinbase, the cryptocurrency exchange platform. The SEC said nothing in response to these events, which would indicate that XRP is not a currency and that Ripple was not in compliance. Former SEC Chair Joseph Grunfest implored the agency to not proceed with the case, warning that it would cause multi-billion-dollar losses to innocent third parties. Deaton also detailed a series of troubling, unseemly conflicts of interest with prior SEC leaders who favored other tokens with much more solid investment contracts arguments while bringing the hammer down on Ripple. And so right there, in case you're wondering, Ethereum, that would be a big part of what we're talking about there. And then also the crazy shenanigans and monetary benefits for Jay Clayton and Hinman based on what had happened in large part during their time as leaders at the SEC, because the firms that they ended up going to afterwards benefited directly from the policies that they set. Coincidence? You tell me. Now, Carol Goforth, yes, the naysayer, Carol Goforth of University of Arkansas School of Law, weighed in on the key question of the Howie Test, whether a transaction qualifies as an investment contract defined by investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. Now, for the SEC's purposes, such a determination deems the asset a security, which subsequently can be subject to disclosure and registration requirements under the Securities Act of 1933 and the Securities Exchange Act of 1934. The term originates from the Supreme Court case SEC vs. W.J. Howie Co., whose defendant was an individual with citrus groves in Florida who kept a portion for his own use while selling real estate contracts to finance future growth. Goforth argued that the SEC is in the right with its determination, but displayed untoward behavior and timing against Ripple. Goforth observes that the value of XRP is derived, at least in part, by the efforts in Ripple. And so let me pause right there. I've been saying for the whole time I've been in this space, which is since November of 2017, that any developer building on top of any blockchain is contributing in some way to that space. And so it would impact the entire ecosystem. So whether it's Coil or XRPL Labs or it's Ripple or pick your developer, they all have an impact, and we can talk about how big the impact of each is. But one of the things about the long-term viability of crypto, it doesn't have to be due specifically to one company. In the case of XRP, it's most certainly not. Now, to me, that's appealing because that will help, I think anyway, ensure the long-term viability of XRP. Which today, it's like nothing certain. I'm very bullish and optimistic for XRP, but I acknowledge I don't know for sure it's going to be around here forever. But damn, if I had to pick one out of all the cryptocurrencies in existence, I mean, hell, XRP is used in enterprise-grade software today. And so it's incredible the degree to which it's been adopted when compared to any of the other 8,000 plus cryptocurrencies in existence. But it's not purely 100% because of Ripple. So it is still fair to state, yes, Ripple, absolutely, they've contributed. And it has affected the market price of XRP, but so has everyone else, right? And so anyway, it continues. However, she is appalled by the SEC's treatment, noting that it waited years to issue the ruling. A similar fate could befall Bitcoin and Ethereum, which are by no means safe from being redefined by regulators. The challenge for Bitcoin, however, is that there is no single party to which the SEC could bring a suit. or perhaps because the SEC would have to sue China, which has controlled the hash rate of Bitcoin for years, which is, I think that's a very solid point. Now, she also observed that XRP has many uses, which the SEC's action has not necessarily precluded. People still use it as a form of exchange, and moreover, the DOJ and FinCEN settlement does not exonerate Ripple of other charges. It is notable that new SEC Chair Gary Gensler has not revoked the case. However, his preference is for Congress to clarify how the SEC should proceed. This admission confirms the view that Gensler's predecessor, Jay Clayton, acted capriciously. Goforth concludes that the regulations are a mixed bag which fall unfairly on Ripple. And so there should be room for reasonable exemptions, and that it will likely take an act of Congress to fix. Yeah, that's another thing that I've been saying forever, because right now it's just this power grab between various agencies, whether you're talking about the SEC or the CFTC. And then there are other agencies where even if they're not directly competing, they still want their piece of the pie. I mean, pick the IRS. There's no shortage of entities in the United States at a federal level that want to rule as much as they can over this entire asset class right now. But Congress, that's where you can go to actually state who's actually got power, who is in charge of this. In the meantime, they're just kind of duking it out, which isn't ideal. But anyway, John Berlau, senior fellow at the Competitive Enterprise Institute, traced the history of financial innovation in his best-selling book, George Washington, Entrepreneur: How Our Founding Fathers' Private Business Pursuits Changed America and the World. And then not how the first president used tobacco warehouse receipts for money. Berlau challenged the view that cryptocurrencies endanger investors, noting instead that misguided regulation increasingly shuts out middle-class investors from financial decisions, limiting their ability to enjoy its benefits. And by the way, I loved reading that, because that's a point that I have brought up endlessly. Basically, the government, they think that you're too stupid to make your own adult decisions, and so they're protecting you from yourself because you can't handle that. That's the way it feels to me. That's it. You're too stupid. Thank you, government, for that. Well, think about all these regulations. And so, yeah, sure, some people, without the regulations, maybe they do worse, but just because somebody else is an idiot, I don't want it to take away from my opportunity. And it does take away from my opportunity when you think that I'm too stupid too. And so if I'm going to mess up, let me mess up, damn it. And so that's the way that I look at this stuff in general here. But it is what it is. And now I've got all these stupid SEC lawsuits as a result of all this. Anyway, the piece continues. He gave the example of Home Depot, which went public in 1981 at $12 a share with only 4 stores. The notion that entrepreneurs can use markets and exchanges to raise capital is increasingly limited. SEC regulation has had the perverse effect of increasing cost and legal and regulatory requirements such that firms must become significantly large before they go public. Larger IPOs with bigger threshold requirement reduce the participation of small investors. And so cryptocurrency emerged as an alternative to centralized finance and offers a way for small investors to get involved, but government intervention hinders this democratization of innovation. And so Berlau highlighted many defects in the SEC's arguments, as well as the downsides for other parties. And he notes that the lack of a working definition and limiting principle for the Howie Test, and how that has led the court to find, for example, in Grenada v. Spitz, that shares in private cooperative apartments were not securities. Even in the Howie case, the court observed that the shares on offer were to the Orange Grove real estate, not to the asset of the oranges themselves. This would seem to be an important point relating to Ripple and XRP, as investors have bought currency, not shares in the company. The test laid out in the Howie case said a security is a product that has its value determined solely through the efforts of others, while the SEC and lower courts have broadened that to any efforts by the product maker to boost the value of the product. Lots of companies that make products that may be purchased as investments such as those that make comic books and baseball cards, make efforts for better product placement and promotion that boosts the value of their products, but that doesn't make their products securities. An interesting thing about dollars is that they would be exempt because the securities laws have a specific exemption for currencies, but as Ripple notes in its reply to the SEC Wells notice, the plain language of this exemption would also apply to cryptocurrencies. Well, how about that? The SEC basically maintains the exemption only to state-backed currencies, but the law doesn't specify this. So again, thank you for nothing, SEC. Levy raised one of my previous articles on replacing Howie with a Ripple test for cryptocurrencies, where a more specific and relevant set of questions would determine the status of a digital token. The demand for a Ripple test is evolving whether the SEC wins its case or not. The conversation has moved beyond the SEC, not only because its credibility has been shaken by its startlingly bad arguments in the pre-trial phase, there is a growing recognition that the treatment of XRP by the SEC has come to symbolize the U.S. government's fundamental misunderstanding of cryptocurrencies, decentralized ledgers, and blockchain technology, and what they mean to the global economy. And so for Deaton and millions of other users of the technology, XRP will either be a triumphant hero or a martyr, but its legacy will play a role in defining the future of the global economy and whether the United States will be a player or a follower. Golf clap for you, Rosalind Lane. I love that. She is so great at this stuff. I tell you, she's got a knack for writing, and the way that she articulately, logically lays everything out is rather impressive here. And it couldn't be more clear. To the unbiased layperson, if you just look at the facts that are publicly available to this point, my gosh, it could not be more clear that XRP itself is not a security. The SEC has an extreme minority viewpoint, but they're also part of the federal government and have a lot of power, so we got to deal with them bitch asses, frankly. So there we are. I'll go ahead and wrap up there. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.